Hello friends, welcome. Friends, today I am going to talk about a case which recently came out as a judgment from TDSAT where DoT lost to the operators as regards to the calculation of spectrum usage charges for shared spectrum. Now friends, I'm 100% sure that many of you who are watching may not be interested at all in this video because the financial implications are very, very small. 1600 crores Reliance Jio is going to gain, and 300 crores Bharti Airtel is going to gain because of their win against DoT in TDSAT. But the main point is completely different here, which people who are really interested in making the process better and understand the nuances of our governance system, what actually we do and which results in arbitrary decision making. The bureaucrats sitting there and taking decisions which sometimes lead to gains for DoT and losses for DoT without taking into consideration the holistic situation under which we function. I will, in this video, talk about not only this case, but will also talk about the AGR case where similar circumstances were there and DoT was lucky because the point which got amplified in this case by TDSAT, which is the arbitrary decision-making process of DoT and because of which DoT lost, was not caught by Supreme Court in the 2011 judgment and the 2019 judgment where a similar process lapse was noticed by TDSAT when DoT did not lay the consultant report before the TRAI consultation process and rejected TRAI recommendation without assigning any reason. Here also, same thing happened. DoT rejected TRAI recommendation without assigning any reason. And not only that, it did not refer the recommendation which it wanted to reject to TRAI as a back reference so that TRAI gets an opportunity to provide their comments and then DoT has got full power to reject, right? So there were two similar situations. In one case, Supreme Court faltered and did not look into the issue of law, and therefore DoT won in Supreme Court and collapsed the industry. The AGR, because of the AGR case, Vodafone Idea is now the brink of collapse. Here, the same thing which DoT did, which resulted in DoT's lost. DoT lost the case, and the financial implication was 1600 crores. Because of Reliance Jio and 300 crores because of Bharti, which is mentioned here. I really do not know whether these numbers are accurate. But friends, there is something more than this, whatever I have described in the overview. And that's why I'm doing this video. The most funny part of this whole issue is that if DoT had accepted TRAI recommendation in totality, then they would have no financial implication without fighting this case. Means what I'm trying to tell you, friends, is that DoT would not have to fight this case. They should have simply accepted TRAI recommendation in totality, and this gain that the operator has of 1600 crores for Reliance Jio and 300 crores for Bharti would not have been there, and DoT would have made a gain of 1600 and 300 crores without having to fight this case, wasting so much of time and having to lose before the operators. Don't you find this whole very funny and, ridiculous? Nobody probably have thought over this, because when I was going through this case, and actually I went through the full judgment. It is such a tedious thing to do. Let me just show you the judgment, not this. This is the judgment. Yeah, this is the judgment. This is a judgment which is quite a long, I think around 140 pages. And I have been reading through this judgment since morning. If you see, I have underlined, many places. And I have created a PowerPoint presentation. And I'm going to take you through the PowerPoint presentation. And the whole thing will be clear, right? It is DoT versus TRAI. Actually, the operators. The SUC sharing saga when arbitrary behavior backfired. Actually, it was DoT versus TRAI, but the case was actually DoT versus the operators, right? Which resulted in loss of DoT. An analysis how flawed implementation, not policy, cost the government, right? Let's go to the core issue. The core issue is as follows, because you need to understand what the core issue was, right, in this case. And then we are going to draw parallel to the AGR case also. So the background was spectrum sharing between TSPs were allowed under the 2015 guidelines. And I'll show you that there is a guideline of 2015. This is the guideline. And if you go through this guideline, it says that guidelines for sharing of access spectrum by access service provider. And here you will find that I underlined here, for the purpose of charging spectrum usage charge, it shall be considered that the licensee is sharing the entire spectrum holding in a particular band in the entire LSA. Spectrum usage charge rate for each of the licensee post sharing shall be increased by 0.5% of the AGR. Means you have to share the complete spectrum. Means, let's say I'm going to show you an Excel sheet so that you understand, because this is very important to understand, right? Let's say an operator has got 800 megahertz band, right? The operator is TSP1. He has got 10 megahertz. There is another operator called TSP2. This operator also has got 10 megahertz. The normal SUC rate is 5%. Okay. Now, normally the weighted average formula would be what? Right? The DoT's method. If you calculate by DoT. So what DoT did? They multiplied 10 megahertz with 5. They came out with 50. And rest of the spectrum band, there was no sharing. So 6.4 megahertz in 1800, 20 megahertz in 2300, and the SUC rate at 3% and 1% depending upon what was there in the NIA. And if you multiply this 2, it comes out to be 19. And if you multiply 20 by 1, it comes out to be 20. And then the total spectrum was 36.4. And if you divide this, if you add this and divide this, his number comes out to be, when I say add means these three items, which is 89 divided by 36.4, it comes out to be 2.45. So what DoT did was, they added on the 2.45, 0.5%. So DoT said, nothing doing. If you are sharing a particular spectrum band, let's say 800 megahertz, then we are not going to enhance the SUC rate of 800 megahertz, which is 0.5 to 5.5. You understand what I'm saying? The DoT said that you calculate the whole weighted average formula based on the normal method, which we calculate, which is the product of this into this, this into this, and this into this, and then you add everything, which comes out to be 89, and then you add all the spectrum, which is 36.4, you come out with 2.45. But in order to take into account the sharing on this 2.45, I'm going to add 0.5, it comes out to be 2.95. This is what DoT said. And I wanted to explain this to you in the beginning itself, otherwise the PPT, it will be very difficult for you to understand through the PPT. What TRAI said? TRAI's method, which is not the full method, because the full method is right here, which basically what I think that the operators and the DoTs were trying to reject, right? So TRAI recommendation is that we have got 800 megahertz band, you're sharing with another operator 800 megahertz band, first operator has got 10 megahertz, the other operator has got 10 megahertz. SUC rate now from 5 megahertz will become 5.5 because it will increase within the band specific, not the full, right? And the rest will remain the same. So the number comes out to be 2.59, right? So the difference is from 2.95, which is the DoT's calculation, and the operator's calculation comes out to be 2.59, because after this, there is no further increase, right? So the difference from 2.95 and 2.59 is the delta, which the operators are arguing that DoT is overcharging. But friends, if the TRAI's recommendation would have been taken into consideration in totality, and which is the TRAI's full method, where TRAI said that if, let's say, if you are sharing 10 megahertz of one operator, which is here, another, let me make it 10 megahertz, so that it will be a apples to apples comparison. So when you calculate the product of this into this, which you raise it by 5.5%, then this will become not 10, 20. Means you have to multiply 5.5 by 20, because this whole spectrum will be seen as if that is 1. So the operator who is sharing, the whole spectrum will be added as it is 1. It is no longer going to be 10, it will be 20. So this becomes 20 into 5.5, which becomes 110, and the rest remains same. And then the total spectrum becomes what? 10 plus 6.4 plus 20 plus 10, which becomes 46.4 versus 36.4. and the overall SUC comes out to be 3.22, which is much higher than what DOT was trying to defend, which is 2.95. Now you got it. So if I make this even 5 megahertz also, the shared spectrum with the other operators, still it is 2.94, which is almost at par with 2.95. So if DOT had taken into consideration the TRAI recommendation, which would have made the overall spectrum of that operator who is sharing equal to not 10 but 15 megahertz and then multiplied by 5.55, there would not have been any financial implication. That is why, friends, I find this whole thing so funny. Now let's go to the presentation. So dispute, as I explained to you, dispute was whether additional 0.5 SUC spectrum usage charge should be added to the SUC of the share band or added to the weighted average, which I showed you. This is a core issue. Now the timeline of the TRAI recommendation versus DOT action. Now you see, the first recommendation was on 21st July 2024. This recommendation was given 0.5% SUC post sharing pooling was recommended, but no WA clarity. There was no WA clarity. Then it was referred back on 27 April 2015. DOT referred to TRAI, asked if 0.5 should be applied to WA or SUC or shared band. Then on 21st May 2015, TRAI gave a second recommendation, reiterate that 0.5 addition, no explicit clarification. Then on September 24, 2015, DOT issued that share guideline. What was the guideline which I showed you here? This guideline. You see, you have 12 and 13, right? Where it was not even clarified whether it is going to be added to the weighted average. See, spectrum usage charge SUC rate for each licensee post sharing will be increased by 0.5 of the adjusted AGR. Now, it does not even say whether it will be on the weighted average or on the band, right? Then what happened? Then we have got 15 January 2020, DOT made a second referral, explicitly sought clarity on WA versus shared. Then on 17th August, TRAI gave a third recommendation, clearly stated only for shared band, not for WA. Then on 11th of October, DOT gave an office memorandum, imposed 0.5 on WA SUC, ignored the TRAI 2020's TRAI point of view. Right? And then the litigation became. Now, one thing you have to understand is that because of the 2011 telecom package, there was a new guidelines which were issued on 8th October 2021, where the SUC increase for shared spectrum was nullified. You see, in order to encourage spectrum sharing, better utilization and efficiency, henceforth the spectrum sharing will not attract any 0.5 SUC rate. So this issue was only valid for that interim period where this was applicable. You see? So after 2021, when the new guidelines were issued, so this was not applicable. This was only applicable from 2014, I think 2011 or 16, whatever it was there in the TRAI judgment, right? Or in the TDSAT judgment. So now let's go back to the PPT. So the TRAI's logical framework was pooling logic. Each TSP sharing a band should be deemed to be using the entire pool holding. Why? Because you can't segregate revenue band-wise. Simplified SUC computation implication, if pooling applied, WA SUC rises naturally, which I showed you, right? So if pooling applied, if you add the two spectrum bands and then you calculate the weighted average, it would rise anyway. So adding 0.5 after pooling only to shared band SUC becomes mathematically neutral, which I showed you almost, and it kind of increased also. It will help DOT to earn more revenue. So what DOT did wrong? It ignored the pooling principle of the TRAI recommendation, applied 0.5 on the weighted SUC that include unshared band. Result is inflated SUC, violated the TRAI's 2020 and 2023 recommendation, breached the TRAI Act because did not assign any reason or referred back the TRAI recommendation in time. Then TDSAT keys finding. DOT failed to follow the due process under the TRAI Act, rejecting TRAI's reiterated recommendation without assigning any reason, held that expert body recommendation must be given due weightage. DOT's read and reject approach is unlawful. And this is what is going on, friends. Bodies like DOT, will always try to behave, try their level best not to get challenged by TRAI. They would try to prevent getting challenged by TRAI, which we saw in the AGR case, which we are seeing in this case also. It does not happen with all officers, but there is a tendency to read and reject. Outcome is the OM quashed, the demand got invalidated. Parallel with the AGR case, which I already described, the AGR dispute, the TRAI recommended a narrower definition. TRAI said that only the telecom portion of the revenue will be treated as the base for calculating license fee. Non-telecom will not be. So the operators were very happy that, and the rationale that TRAI gave, the TDSAT gave, that which actually the TRAI recommendation went to TDSAT, that the TRAI's consultation process was not properly followed, or DoT did not hold an effective consultation because it did not hand over the consultant report, which it was consulting on a private. They hired a consultant. DoT hired a consultation in parallel when the TRAI consultation process was going on, and did not hand over the report to DoT, and rejected the recommendation of TRAI of TRAI without assigning any reason. DoT rejected without assigning any reason. TDSAT supported TRAI. Supreme Court, and this is very important, friends, and that's why we are in this mess. Supreme Court ignored the procedure violation, which they had taken into consideration in many cases. If you read the TDSAT judgment, they have called out Supreme Court cases where Article 14 has been called and said that if you are holding a consultation process, if DoT is a party to a consultation process, and when the inputs are fed to DoT, they can't simply throw those inputs in the dustbin. They have the responsibility to consider and give due weightage to those inputs, which comes from TRAI. After the stakeholders have submitted their comments, due weightage has to be given. What does due weightage mean? Due weightage means that if you are rejecting any of the recommendation, you have to explain, because so much effort has gone into in the process of creating the recommendation, where TRAI has taken so much amount of effort to. DoT cannot simply say that I don't agree with you. They have to give reason, and this has been a position of Supreme Court and TDSAT in many cases. Unfortunately, in the Supreme Court case of 2019 and 2011, they ignored it. And that is why we are in this mess, friends, of the AGR. Today, the whole telecom industry is in the collapse because Supreme Court did not look into the aspect that how DoT can reject TRAI recommendation without assigning any reason, right? So in both cases, DoT acted arbitrarily, triggered a major litigation, created a massive industry disruption, right? So consequence of DoT's arbitrary conduct is, in the SUC case, try to maximize recovery but ignore the procedural safeguards, ignore pooling inflated base plus 0.05%, handed operator a legal win. You can imagine that. They could have achieved the same objective which I showed you in my Excel sheet. This is the TRAI full method. If DoT has accepted the TRAI recommendation in full and added both the spectrum of the operator and then enhanced this by 0.5, they would have achieved the same thing, even more. But foolishly, what DoT did, they came out with a new method. I don't know why. They could have followed the TRAI recommendation because it makes sense. If you can't separate out this two spectrum band, it should be pooled into the other operators from the point of view of calculating SUC. It's quite natural. And then you increase by 0.5, right? So the same financial outcome would have been possible, but without any legal defeat and loss of credibility. So the key takeaway is, had DoT followed the TRAI recommendation, pooling per share spectrum usage charge, it would have achieved the same financial outcome, maybe more, without any legal defeat. Instead, it is a half-baked arbitrary method. It has looked like fools. It is looking foolish. You can see it very clearly, If you had added the two spectrum band and if you have made the calculation, this Excel sheet clearly tells you that this method, TRAI method 2, which is the full method, and the DoT's method would have resulted in same, almost similar. And if this was 10 megahertz, this would have given a much higher SUC to DoT, right? So expose the governance flaw and resulted avoidable litigation. So you could have resulted in avoidable litigation. So the final thought, the cost of arbitrariness is real. You can't read. You should take an effort. You should read and take an effort. Don't, because what happens is that sometimes it appears that the DoT has already decided. The TRAI process is just for the namesake. They are not even interested in what TRAI is doing. Then what is the purpose of holding and wasting so much amount of time, friends? Right? You should be interested. You should be looking at TRAI's process with a lot of interest, right? If you have decided yourself, then naturally you will not assign any reason because you are not interested in TRAI's process, right? So it resulted in revenue loss, regulatory confusion, industry mistrust, time for structural reform. This is important. See, every constitutional body in India has to do their job. And it takes effort to do the job. You have to read through. You have to basically analyze. You have to logically conclude. And then you have to give reason. When you start giving reason, then you yourself unlock your brain and try to understand that whether those reasons are really correct or not. Then you challenge yourself. If you don't give any reason, then you make mistakes like what you have made right now, resulting in a loss of 1,600 crores plus 300 crores, right? Ensure that the ensure reasoned government decision making, avoid policy arbitrary without any legal clarity. So friends, that's all in this video. I hope that you understood the implication of this case, and I really wanted to do this video to draw parallels with the AGR case, because that case has destroyed this industry. Now, minister is saying that they are not going to give any relief to Vodafone Idea. But look at this. DoT themselves were responsible. Now, if you are going to basically put your hand saying the Supreme Court has come out with a judgment, you defended, you put your lawyers out to fight the case, and not even take into consideration that if you let a case go in such a way and take such unreasonable stand, things will be out of your control. That is exactly what has happened right now, right? So it is now the responsibility of DoT to unwind what mistakes that they have done. So they have to take some step forward, some risk that they have to take now. They cannot say that they can't do anything about that right now, because if you are going to be so passive, and then these mistakes will keep on repeating, you will lose now. Nobody is pointing to this, that you have lost 2,000 crores, right? Because people are not even aware. People have to take some time to read all these judgment, friends. So that is why, friends, I feel so disgusted, and I feel very sorry about the situation that we are facing in our country, friends. Because our system has to do their job. Our institutions have to be more responsible, friends. Anyway, friends, thanks for listening till the end. And I'll come back with a new video on a new topic next time. Thank you very much. Thanks a lot.